Okay, we are live. Hi, this is William Ramsey. Welcome to William Ramsey Investigates. On today's show, I have a very special guest. His name is C. Evan Stewart. Last name is spelled Stewart. And if you're watching this on X, Rumble, or Rockfin, you'll see the title to his new book. And the full title is The Worst Supreme Court Decisions Ever! Exclamation mark, and related tales. There's a lot in this book, but it's an interesting take because usually people analyze these Supreme Court decisions with this kind of August kind of view, but this is kind of a refreshingly different take. I would recommend this book. Definitely, I was reading through it. Mr. Stewart just retired, so congratulations to him. He did specialize in securities litigation, and he is an adjunct professor of law at Fordham University and has taught courses at Cornell's summer law program in New York City for 17 years. He's a columnist for the New York Law Journal and a member of the Council of Foreign Relations. He's done a biography of Myron C. Taylor, who is the chief benefactor of the Cornell Law School and FDR's ambassador to the Vatican. And that was published in 2023. And we were talking in the pre-show, he's just finished a book on a very interesting figure people should know more about, and that's Stewart, who was the vice president under Abraham Lincoln. So I'm looking forward to looking that over. But again, today we're going to talk about this book that he just published, and it is The Worst Supreme Court Decisions Ever. So, C. Evan Stewart, welcome to the show.
Thank you, William. Thanks for having me. This is an interesting subject, especially now, because we live in this hyper-politically charged era where, for better or for worse, the Supreme Court is being subject to a lot of political pot shots. Senators stand on the steps of the Supreme Court, literally threatening them with physical violence. We've had one person arrested trying to assassinate a sitting Supreme Court justice. It used to be said, James Madison once said, the Supreme Court was the least dangerous branch of the federal government, and it doesn't seem to be that way.
Riots in front of people's houses, right, and all this stuff, like very personal things. Yeah,
it's really terrible, and part of this book is an attempt to sort of pull back from that, while at the same time pointing out that the Supreme Court is not new to the area of making what a lot of people think are horrible decisions. They've been doing it for 200 plus years. And it's not just one side of the aisle or one group of people or one people just from the North or people just from the South or one ethnic group versus another. This is an equal employment violator of basic rights all over the place. And it's really an astonishing thing. I came to doing this, William, because you mentioned the course I teach at Cornell. This is a course to help undergraduates to decide whether they should go to law school or not, and to sort of expose them to what law school is really like. And in putting together the course, literally 20 years ago, I thought I should devote at least one class, to really terrible Supreme Court decisions for two reasons. One is most people don't even study American history, let alone know anything about it. And secondly, and this may be incredible to believe, but virtually all of these decisions that are in my book are so terrible that they aren't taught in law schools. People are just law professors are embarrassed to even talk about them and teach them. So when I was putting these together, some of these decisions I'd never even heard of. And when I talked to other experienced lawyers, they'd never heard of them either. Some of them are pretty well known now, and some are known for the wrong reasons. And so some of those are in my book as well. So
what I liked about your book is you actually provide the history behind some of these infamous cases too. So not only are you getting this case as it reaches the highest court, but you're understanding how it got there and helping the reader to understand that too, and putting it in the historical time frame, which I think is really important.
Yes, thanks. So that's really an important goal of this book. This is not written for senior partners at law firms or legal academics to help them understand these cases. This is to help people who genuinely are interested in American history and the role of the court, and really are coming to those subjects with little or no knowledge. And you can't understand some of these decisions, or you can't literally understand virtually any of them without understanding why they're in front of the Supreme Court, what's going on in the country at that time, what's the impact to the American, not just the legal system, but to American life in general. So, for example, the Dred Scott decision, which is the worst decision in history, in which the Supreme Court in 1857 said, among other things, and I have to put this in context, it's one of the most vile and racist screeds dressed up in a legal decision. I don't mean to laugh about that, but it's so terrible. It's sort of hard to even come to grips with it, because the Chief Justice of the Supreme Court ruled that African Americans were not and could never be American citizens. And that case, as bad as what I just said is, as a legal matter, that case leads directly to the Civil War, in which over 700,000 Americans died, which was 2% of the population. So that type of decision has humongous consequences, not just in the law, and I'll come back to the law in a minute, but also to normal, regular people who aren't following this, don't have a stake in the fight, don't really understand what's going on, but it has real consequences. Now, one of the other consequences besides that leading to the Civil War is the Supreme Court made up a doctrine which is still bedeviling us, you and me, and everybody else in the country today, called substantive due process. And I don't know if that's a phrase that you are familiar with, but that's where
familiar with the due process clause, but not substantive due process.
Right. So when people, to the extent people have a general or faint feeling about due process, they think it's someone's entitled to a fair trial. Someone's entitled to having a jury of their peers make a decision about whether they're guilty or innocent, playing by a set of rules that we all agree by. And that's basic due process. Substantive due process is something very different. And it was literally invented by the Chief Justice in 1857, a guy named Roger Taney. And you find rights in the Bill of the Amendments, Bill of Rights, that aren't really there. So for the first time, Chief Justice Taney, and he got obviously a majority of the court to go along with him, found that there was a right in the Fifth Amendment, which is the Due Process Amendment, that you could not restrict people in the United States from taking their, quote, property, close quote, wherever they wanted to. And that to deprive them of that right was to deprive them of their due process rights. Now, you can search all day long in the Fifth Amendment to find that there being some property right in the Fifth Amendment. It doesn't exist. But the import of what he was doing in finding that right was allowing Southerners to take their, quote, property, i.e. their slaves, into any territory that wasn't organized into a state at that point. And this was a point of real contention, really gave rise to the Republican Party, because the Republican Party said slavery had to exist where it was and could not expand. And the Southerners took the position, well, we're Americans, we can take our property wherever we want to. And this decision codified that by making up this right that doesn't exist. But this was sort of like opening up Pandora's box. because this then leads to the court finding other substantive due process rights, like the right to contract. So, for example, there's a later decision called Lochner, where the Supreme Court overturns a New York law that says you can only work a certain number of hours a week. And the court said, well, no, there's in the Constitution, there's a freedom to contract that if we're a country of doers and entrepreneurs and go-getters, and if Evan Stewart wants to work 100 hours a week, New York State can't limit him to 60 hours a week. Well, where do you find that? You say, well, there's a freedom of contract. And this leads to all sorts of consternation. Virtually all of the New Deal legislation for the first 3 years of the New Deal in the 1930s is thrown out by the court on this premise of the freedom to contract, the substantive due process right. And only when Franklin Roosevelt threatens to pack the court does the Supreme Court, the famous expression, switch in time saves nine, literally does a pivot and changes its entire jurisprudence to avoid the Supreme Court being impacted by Roosevelt. But that's not the end of substantive due process. It comes back later in the 1960s in a case called Griswold, which finds that there's a right to marital privacy. And where does that exist? It doesn't exist, according to the court in that decision, doesn't exist anywhere, but in any specific amendment, it sort of deals from, or arises from a whole bunch of different amendments together, and they form together in a cloud. And in this cloud, you find this right to marital privacy. And the court said, but this is we're only finding this with respect to marriage, because marriage is a sacred thing going back thousands and thousands of years. But then a couple of years later, they expand that to abortion, and later to people's right to marry who are same sex and things like that, which have led to all sorts of societal issues. And of course, the whole abortion issue went on for 50 years before the Supreme Court turned around and reversed itself fairly recently. So this whole thing about substantive due process is a huge, huge issue about who gives these 9 people the power to make stuff up. Right. That you can't find it anywhere, but they just make it up, and you can't get rid of them, because every 2 years we can get rid of our Congress people if we think they're idiots. But if we think the people on the Supreme Court are idiots, they have lifetime tenure. So we're sort of stuck with these people if they do these things. So when the court goes in these areas, it has very profound consequences. Obviously, a lot of people thought the abortion decision in Roe v. Wade was great, but the other half of the country thought it was murder. And those two groups were never going to agree, and they never agreed. And what the court said now is we shouldn't be in that business. That's for elected officials to make those decisions, not 9 unelected people. And the irony of that, of course, is that the Democrats have used that very successfully to influence a lot of voter turnout. And it's been the very people who cried out that the court was reversing Roe have actually benefited by it politically. So
it's interesting. What's also interesting is the history is still ongoing today. Are these activist judges, are they making things up? Are they sticking to the Constitution or the laws? And also threatening to pack the court. It's never gone away. So like they're threatening to pack. And also it shows the impact of what you're saying, unelected people, how it affects all of us. Once it gets to the Supreme Court, it's the Supreme Court, right? So they almost can kind of rule on things that affect, now it's 350 million people. It's incredible to think about it.
Yeah. And it really does, it depends on, do I agree with this or not? So if I have a particular viewpoint and the Supreme Court agrees with that, I think the court's doing a great thing. If it goes against what I hold, then it's the court is this vicious monster that's trying to ruin the country. And the irony, one of the things that I talk about when I'm talking about the book is the misinformation that is spewed out in the mainstream media about what the court does, what the court's purpose is, what the court's history is just so unfortunate and misleading. It's quite unfortunate. So the one example I think is very helpful is if you remember when the Obamacare went up to the Supreme Court, and a lot of people on the Republican aisle were saying this thing is unconstitutional, it's just terrible, and the Supreme Court should throw it out. And there was a big controversy at the time because Obama did not want the legislation to be based upon Congress's taxing power, because he didn't want the Republicans to say, well, you're just raising taxes by this new health care. So he wanted to take that politically off the table. But when it got to the Supreme Court, the government representing the Obama administration had to admit, of course, that this was based upon Congress's taxing power. That's the only basis that Congress has to regulate the economy in this way. And that concession by the government actually saved Obamacare, because it turned a 5-4 decision to throw it out, because if it's not based on the taxing power, then it's not based on anything, and Congress doesn't have the authority to do that. But once they made that concession, then Chief Justice Roberts changed his vote. And this is where I think people don't understand, for example, what Chief Justice Roberts is trying to do. He's actually quite an important person trying to restore the institutional mainstream and values of the court, and he once called it, his job was to call balls and strikes. And this is a classic example of exactly what he's doing when he's calling balls and strikes. When he changed his vote, when the government made that concession, what he was saying was, well, I may think this is a stupid law, and I would never have voted for it. And if I'd been in Congress, I would have been thumbs down. But that's not my job. My job is this constitutional or not? And does Congress have the authority to do this? And if the answer to that is yes, then my job is to not say, but it's a dumb law and I don't like it, so I'm going to throw it out. So here's somebody holding his nose. Not my politics. I don't think it's good, but that's not my job to say whether it's good or bad. That's why we elect 535 people to Congress to make these decisions for us. And if the American people after 2 years or 4 years don't like it, they have a remedy for it. And so that's where Roberts is trying to pull the court away from this substantive due process, us substituting our judgment for the Congress, and doing what the court really should be doing is, does Congress have the power to do this or not? And he ruled, obviously they do, once they made that concession that it's under the taxing power.
Right. So you see how much of this affects the legislation too. Like they're validating legislation that comes out of Congress. There's a lot of other cases. This is shows how influential the Supreme Court is in validating all this stuff. I don't know why that took off. But maybe you can talk about other cases where the Supreme Court really influenced American history like that. Like we're with Obamacare, but they've made decisions that have had very intense things. Native Americans, Japanese Americans, people they thought who were simple-minded, right? So there's a lot of those cases that really affected other people.
Yeah. So let me talk about the Korematsu decision, since you alluded to that. So that's a decision, I call it the third worst decision in the court's history, where in the aftermath of Pearl Harbor in 1941, the government of Franklin Roosevelt issued an executive order that allowed the government to round up 120,000 American citizens. This is people that don't like to phrase it this way, but these weren't Japanese people. These were American citizens of Japanese origin whose parents or grandparents or great-grandparents had been born in Japan, but they were American citizens. And we rounded up these people and put them in concentration camps. Literally, they weren't country clubs. They were places with barbed wire and machine guns and military guards, and that's where they stayed for virtually the entire period of World War II because of the general hysteria, especially on the West Coast, of what happened at Pearl Harbor and the fear that the Japanese were going to invade the West Coast and whatever they were going to do once they invaded the West Coast. And this is just out and out blatant racism. In the fervor of the panic of Pearl Harbor and the terrible things that happened there, and all the setbacks in the Philippines and Guam and everything else that happened at the beginning of World War II in the Pacific. But the government went ahead and did this anyway, even though a number of leading people in the government, even the Attorney General, thought this was unconstitutional. But anyway, Roosevelt issued this order and it went into effect. And this one fellow, Fred Korematsu, who was a very decent man in San Francisco, was rounded up and put in prison, and he appealed. And it went up to the Supreme Court, and the Supreme Court, in really just an awful, terrible decision, 6-3, ruled that this was fine. And I talked about not discussing these things in law school. When I took constitutional law 50 years ago, we were taught about this standard called the strict scrutiny standard that is to be used whenever a law is being applied with respect to some social or racial or some type of setting one group against one another. And if you're going to do that, it has to be held to a very high standard, strict scrutiny it's called. And that was taught to us, and we all nodded and took notes and were ready for the final exam on that. But we had no idea where it came from. That doctrine was invented by a fellow named Hugo Black, who was a Supreme Court justice. In this case, he wrote the majority opinion. Now, Hugo Black is sort of an interesting fellow. He was a Supreme Court justice, but before he was on this court, he was a senator from Alabama. Before he became a senator, he was an ambitious young lawyer. And to further his ambition, one of the things he did in Alabama was join the Ku Klux Klan. So here's a former Klansman who's ruling on the applicability of a law to put 120,000 American citizens of Japanese origin in concentration camps. So he invents the doctrine of strict scrutiny. He says, well, this is obviously a racial characterization. We're applying this to one group of people. And does this meet strict scrutiny? And in one sentence, he says, of course it does. We're at war with these people, and they're a security threat. So obviously we have to do this. The only problem with that is, it obviously didn't meet the strict scrutiny standard, but also there was no evidence that any of these people had been disloyal. Right. In fact, the unfortunate irony is the extent the government put forward any evidence of disloyalty or treasonous acts, it was all fabricated.
Right. So they found that the actual court record was fabricated by some people. Yes.
Yes, by the government.
Yeah.
And this wasn't done until years later. But anyway, here's Justice Black saying, well, of course we meet this tough standard because we're at war and these people attacked us at Pearl Harbor. So of course we do. And 5 other people, very eminent. I mean, Felix Frankfurter, one of the most brilliant Supreme Court justices in history, nodded and went along with this and said, yeah, we're at war. And of course, if Franklin Roosevelt thinks it's a good idea, it's a good idea. Importantly, 3 justices dissented. And one of my great heroes, a guy named Robert Jackson, who later was the chief prosecutor at the Nuremberg trials, he said this was, let's not kid ourselves, this is blatant racism. There's no evidence of this, that they've done anything wrong. None of the evidence put forward by the government has been subject to any cross-examination or any scrutiny of any sort, which is obviously the test of any real evidence to a lawyer. It's not just one-sided evidence, it has to be cross-examined. And he said, more importantly, we've crossed a basic threshold. He said, because what the court is saying here is, in the case of a national emergency, i.e. an existential crisis of a world war, it's okay to do whatever the hell we want to do, including putting 120,000 Americans in concentration camps without evidence. And he said, what we've done now is cross the threshold. We've put and he used a very vivid image, we put a loaded gun on the kitchen table of the country. Wow. Waiting for the next emergency for someone to pick up that gun. And that's a very powerful image that stays with me, at least, always, because if you may remember in the 2016 election, then candidate Trump invoked that decision, the Korematsu majority decision, as justification for some of the things he wanted to do about immigration. So
it reverberates. All these decisions reverberate. This decision is still argued over it. I think Judge Roberts, who's the head of the Supreme Court, or Chief Justice, thank you. He was involved in kind of overthrowing, or there was a coram nobis.
Yes.
So, I mean, it's really incredible. And those people lost all their money too, by the way. They were like heroic people who saved their farms and houses and stuff like that. But some people bought up their property on 20 cents on the dollar, like horrible stuff. So
yeah,
it's a real stain on the country. Yeah.
Yeah, it's quite similar to when the Nazis dispossessed Jews of their property. To the extent they were alive at the end of World War II, they didn't go back to their homes and find them intact. It was all gone. So it's just a really, really terrible thing.
One of the interesting aspects is some of those Japanese men who were in those concentration camps were sent to the Western Front, and they were the most highly decorated fighters for the United States. So it's like crazy to think they were disloyal. It's like, wow.
Yeah, there came a later point in the war. By 1944, the federal government started to parse between those people of Japanese origin who could literally affirmatively prove their loyalty. And if they could do that, then they could be eligible for military service. And you're right, the most decorated unit in World War II was in Italy, which were the Japanese American soldiers. And I tell the story in the book. Daniel Inouye, who won the Medal of Honor in Italy, lost an arm. Ultimately, he became a senior senator from Hawaii. He came back to the United States after World War II ended and went into a barber shop in his uniform with all of his medals and decorations and everything else to get a haircut. And the barber said, "We don't serve no blanking Japs here." So they're pretty jarring. I mean, some of these stories are pretty jarring. I mean, we like to think of America as a wonderful place, and it has very, very wonderful things, but we've had some bad experiences in our history that it's better for us to at least be honest with ourselves and come to terms with them, which is, again, one of the reasons for this book, to not just say we're terrible, but we have done some bad things over time. Ultimately, we've come back to correct them. But yeah, there's some bad experiences. So you mentioned before there was infamous decision, Buck v. Bell, in 1927, where legendary Supreme Court Justice Holmes, Oliver Holmes, on trumped up evidence, said it was okay to sterilize a woman who was, quote, feebly minded, and she wasn't. And the famous phrase, 3 generations of idiots is enough, reverberates from that decision. And again, that has consequences because the Nazis used that to justify what they did in World War II. They turned those words right back against us and said, well, what do you mean? We're not an outlier. Legendary Supreme Court Justice Oliver Wendell Holmes believes this too. So
yeah, a lot of that eugenics material that was right there at the turn of the century went to Nazi Germany, inspired them. It's hard to believe, but people think the Germans came up with it, and it's not true. When I grew up, I had a lot of those eugenicists names in California were they were the names of my schools, Terman, and some of these other characters who were involved in kind of like the mid-century eugenicist movement were heralded. It's hard to believe.
No, it was a very popular, well-regarded. I mean, Harvard was one of the big proponents of this. The so-called Boston Brahmins. That's where all this came. The whole Brahmin baloney came from. They were better than everybody else because of their genetic makeup, and so this is really horrible because it was so well accepted by the, quote, better people, so that they knew best, and it really reached its terrible peak or nadir in that decision, Buck v. Bell.
And there were actual that justified like sterilizations, 40, 50,000 people sterilized in Virginia alone, I think. The numbers were pretty vast, if I remember.
It was a large number, and not surprisingly, I won't say all, but somewhere between mostly to virtually all women, because the way the sexism in society and the medical profession generally, excuse me. So it's just a horrible episode in our history, which nobody likes to talk about because you can't possibly justify it on any basis at all. And it shouldn't have been justified then, but it was sanctioned by the Supreme Court.
Right. Yeah. Went all the way to the top. And it's kind of like Oliver Wendell Holmes is considered probably one of the greatest justices of the Supreme Court. But you just kind of, he was, I don't know how you justify it, maybe a product of his time to a certain extent, of what they thought was science back then, or they hadn't seen the horrors of these ideas. I don't know.
But he was a big part of this eugenics group. I mean, he was a Boston Brahmin himself, and he believed that right down the line with all the other ones. Yeah,
it's remarkable.
It's
another one. Like we covered Korematsu, Dred Scott, Buck v. Bell, Plessy versus Ferguson was another one. It just shows like these aspects of our culture really were handled, maybe mishandled, when these disputes made it up to the Supreme Court. I think your book shows that. One of the other aspects of the book I recommend is that at the end of each chapter, Mr. Stewart adds a further reading so you can see other kind of modern scholarly. I haven't gotten to them yet, but like you can go on it for further research if you have an interest in any specific case that he covers. There's other scholars that you can kind of dash off to and read as well. So I like that aspect of the book. You don't see that often.
Yeah, thank you. That's really there. I don't want people to think I'm the only person or the last word on any of these subjects. People disagree on some of these cases, and that's fine. I think the more information people have about these, it's better. Taking one person's view on anything is not the best approach to anything. It's the more you know, the better. So that's the point of all those additional notes at the end of each chapter.
Evan, maybe the next thing we can do, we're at the 35-minute mark. This isn't just a history book. It doesn't just deal with cases in the 19th century, but modern cases. Well, I think you mentioned LBJ in the court and Nixon in the court, and how politicians are always cognizant of what's going on in the Supreme Court to kind of fulfill their agendas too. Maybe you can address something like that before we wrap it up.
Yeah, so that's what the related tales in the title relate to. Excuse me. So besides just the worst cases, I thought people would be interested to know how some famous people have dealt with, have had incidents in the Supreme Court. So Lyndon Johnson would never have been president, but for a special appeal that's very big in the news today. The lead article in the Wall Street Journal about the special appeals to the Supreme Court. Well, the special appeal to Hugo Black, guy I mentioned before, by Johnson's attorney, who ultimately became a Supreme Court justice himself, Abe Fortas, secured Lyndon Johnson's victory and led to him becoming a senator in 1948. But for that special appeal to the Supreme Court, that never would have happened. And so that's an interesting. So think about if Lyndon Johnson had never gotten to the Senate, who would never have been president, what would have happened with Vietnam, the Great Society, all the riots in the 1960s, everything else? Who the heck knows? John F. Kennedy probably would never have been president because he only became president because Lyndon Johnson was his vice president and won all those southern states for him. So lots of consequences came from that special appeal. What's interesting to me about that is not just the consequence of Lyndon Johnson in the Supreme Court, is his lawyer, this fellow, Abe Fortas, was one of the most brilliant lawyers in America, no doubt about it. And he came in and advised Lyndon Johnson against the advice of every other lawyer that was advising Johnson, whose career was hanging in the balance, literally in the balance, teetering on the precipice, to follow a strategy that everyone else thought was nuts. And Johnson, who was a real riverboat gambler, he pushed all his chips into the middle of the table and said, "Let's do what Abe says." And if Abe had been wrong, he would have gone back to Texas and sold insurance or done whatever he would have
gone to jail. I mean, I think he was in trouble too at certain points.
That was later.
Okay.
But this legal strategy that Fortas employed, which read the chapter because it's so cool. It was the highest risk possible strategy, and it worked. It was absolutely brilliant. And you can see why Lyndon Johnson thought Abe Fortas sort of hung the moon after he won that for him. And then Richard Nixon had this amazing case in the Supreme Court where he argued this case. And everyone thought it was one of the most brilliant arguments ever made. And it's an insight into who Nixon was, not the Nixon that we sort of think of in this sort of cartoonish, menacing Watergate prism that we all know him through. He's probably one of the brightest men ever to be president. A really, really smart person. He had some demons, no doubt about that. But the way he argued this case in the Supreme Court, he argued it twice. Everyone thought it was absolutely brilliant. Even the New York Times, the Washington Post, Abe Fortas, who was on the court at that point, thought that Nixon was like the gold star of advocates in the court. And so it's a really interesting insight into Nixon. Some people call it the good and bad side of Nixon, into the good side of Nixon, the very smart, hardworking, very
Duke Law School. I think his nickname in law school was Iron Ass or something like that.
Exactly right.
Something like old Iron Ass or something.
That's right.
He's always sitting there reading, to his credit, because you have to read a lot.
Yes, you do. Law school's a lot of reading.
Yeah, sure is. And you have to be able to absorb it as well. So absorb it and contextualize everything. So it's a lot of work. But
can I tell you a sort of funny story? I've mentioned this fellow Hugo Black at least twice already. And he was a very interesting justice, had a very interesting career. And toward the end of his career on the court, he was blind. And this was the time period when the court was rendering a number of decisions on obscenity. And these involved a lot of pornographic movies. And so the court literally, in the basement of the Supreme Court building, set up a theater where they were 9 men at this point. Sandra Day O'Connor not joined the court. So it was 9 men over a certain age watching these pornographic movies to determine whether they're obscene or not.
Right.
And Justice Black is sitting there, and of course he can't see anything. And who is sitting next to him telling him what's going on in these movies? But the first African-American justice on the court, Thurgood Marshall. So here you have Thurgood Marshall explaining what's going on in the movie screen to a former Ku Klux Klan member. It's like, is this a great country or what?
Really.
This couldn't happen anywhere else.
Their characters too, like a lot of interesting characters in the Supreme Court. So that's another book in itself, is how these different lawyers and different people, and even the makeup of the current court. I mean, some of those to get there, they are the creme de la creme of the most. They used to be. I don't know if they are now, but definitely some very, very intelligent people. Like they're usually at the top of the legal profession. Generally, would you agree with that?
Generally, it's like most things. It's a mixture. Sometimes people are put on for purely political reasons. I remember a former deputy attorney general telling me that the reason that John Paul Stevens was put on the court was because Gerald Ford wanted a good Midwesterner on the court before he ran for re-election in 1976. Now, that's not to say that Stevens wasn't qualified. He was a very good lawyer. He had been a Supreme Court clerk himself, but that's why we ended up with Stevens. Why did we end up with Sandra Day O'Connor? Reagan wanted to put up a woman, and there were very few women judges in America at that point. And she had gone to Stanford Law School. William Rehnquist, she had a better law school record than William Rehnquist, who was obviously very bright. Rehnquist actually had lusted after her in law school. That went nowhere. But so was she the only person in America? No. I mean, when George Herbert Walker Bush nominated Clarence Thomas, he said in 2 sentences, one, race had nothing to do with it, and he's the most well qualified person in America to go on the court. Well, those are 2 of the biggest whoppers that George Herbert Walker Bush ever told. So some of these people go on the court for reasons that are political, and others, and some of the very best judges don't ever get up to the Supreme Court. Henry Friendly of the Second Circuit should have been on the Supreme Court.
Learned Hand, I think you mentioned in your book too.
Yes, Learned Hand never got to the Supreme Court. Richard Posner never got to the Supreme Court.
Right. What's that called? Law and Economics, isn't that his famous?
Yes, yes. So
I think you mentioned he's like one of the most quoted legal scholars out there on top.
Yes. He's really a brilliant, absolutely brilliant man. And so if brilliance was the only qualification, he would be on Snap Your Fingers. And similarly, obviously, Robert Bork. If you're just looking at sheer brilliance, Bork hands down should have been on the court. For political reasons, he did not get on the court. But if it was sheer, I mean, Robert Bork transformed the study of antitrust law. He's the most important scholar in antitrust law of the last 50, 60 years. And as I point out in the book, he saved the Justice Department in Watergate when he was Solicitor General. So, I mean, he was quite a fellow. We look at him through a prism now of he lost, and people called him lots of bad names and things like that. And he was sort of a poor loser when he lost. But up to that point, he had an absolutely stellar career.
So, not always the best and brightest on there, but still pretty bright. To be a clerk for the Supreme Court is definitely coveted. Like I think that's a very competitive.
Yes. Yes. Very, very highly sought after.
Yeah. And though, I mean, yeah. Anyway, great book. Is there anything you'd like to add or anything I missed before we wrap this up, Evan?
Just you can find this book. Just click my name, Google my name, and the name of the book, and you'll see it pops up on Amazon, and you hit the order button, and it'll arrive the next day. So that's probably the most efficient way to get the book. If people have questions or comments or critiques, they can reach me at cevanstewart@outlook.com. Happy to engage in any dialogue with people about the book.
It has excellent ratings. You have 44.9 ratings, so you definitely have some very satisfied customers, I guess. You also have Kindle, so Kindle hardcover.
Yes.
And you also have other books coming out as well. Is that correct? You've done the book on Myron Taylor, who I'd have never heard of. I don't know who that is.
Yeah, Myron Taylor, one of those consequential people of the 20th century that no one's ever heard of because he didn't believe in self-promotion. But he was at the epicenter of 8 or 9 of the most important issues of World War II. We'd all be speaking German now, but for Mr. Taylor, because Mr. Taylor made sure that Lend-Lease aid got through to Russia. And had that not taken place, Russia would have gone under to the Nazis. And World War II would not have ended the way it did if the Nazis had overrun the Soviet Union as they were.
Stalin famously said, "We were right at the end of our rope, and the Lend-Lease program saved us. Like we were almost done."
Yeah, that's absolutely true. He actually toasted Roosevelt at
Yalta or something.
Yalta, saying that, but for Lend-Lease, they would have gone under. And there's no question that's true. No question that's true.
Amazing. So Myron Taylor, there you go. That's another show. I've never heard his name. It's sad to say. I love history, but it's another book.
A great guy. And as we meant, I was talking to you before. I just finished a book, my 4th book, on William Henry Seward, and his role really is the one man who tried to hold the country together between the election of November 1860 and Lincoln's inauguration in March of 1861. And he literally kept the Upper South in the Union over those 4 months through just an incredible effort, one of the great men of American history. And this is an episode that people don't know about because we have this fixation on Lincoln as being a saint. And Lincoln was undoubtedly the greatest president. But when he took office in 1861, he wasn't really ready to be a president of the United States in an existential crisis, constitutional crisis of secession. And he made some big mistakes. And resupplying Fort Sumter was one of them because that triggered the Civil War. And that's the story I'm telling in this book about Seward.
Yeah, and Stewart was supposed to die during that plot against Lincoln, right? They sent somebody to his house,
and the fellow did knife him in the neck, just basically missing his major artery, but it completely disfigured his face and the rest of his life. He didn't like to be in public that often because he used to be a fairly good-looking young man, but this knife marks went just like that.
Wow. And I had no idea it was that serious.
Yeah. Wow. Yeah, but he was quite a guy.
Do you have a working title for that book?
It's William Henry Seward, The Secession Winner, November 1860 to April 1861.
And when do you think it'll be published? Like how soon?
That'll be out in probably the end of this year.
Gotcha.
And I literally just sent it to the publisher a week ago.
Gotcha. So people keep an eye out for that. I'll be keeping an eye out for that as well. And I will put a link to the book in the show notes as well as your email. So if people want to follow up with Evan Stewart, please do. And again, the book we talked about today is The Worst Supreme Court Decisions Ever and Related Tales. And the guest is C. Evan Stewart, Stewart. Thank you so much for your time.
William, thank you. This has been a real pleasure.
Yeah, likewise. Stay there. Stay there.